Hi there, Doc from Barcast Audio here today to talk with you about the first video in our series on constitutional law on the bar exam, some key multi-state bar exam principles, UBE principles that you can use to score better on the bar, especially the multiple choice questions. We're going to be starting off by a discussion of judicial review as tested on the bar exam. Let's jump right into it. So we begin with judicial review. Judicial review on the bar exam is really aimed at this question of what is a case and controversy. Article 3 of the Constitution provides courts, federal courts, with jurisdiction over cases and controversies. And now what exactly constitutes a case and controversy is basically going to be the subject of any of these questions you see on the bar exam. Now, this subtopic is going to be one of the more important subtopics you see on the MBE because it is going to make up 4 to 5 questions of your con law set. So if you can get all 4 or 5 of those questions right off the bat, you're off to an incredible start. Let's kind of jump into some of the key basic principles that you need to know for judicial review. So there aren't that many ways that judicial review can be tested on the bar exam. Let's just briefly run through them. So the first way that judicial review can be tested on the bar exam is just the blanket question of whether there is an actual case and controversy here. And I'll explain this in a little bit greater detail in a moment, but just know that the first way is there an actual case or controversy here? The second way this subtopic can be tested on the bar exam is whether a party has standing to sue. Do they have standing to actually initiate the lawsuit that is the subject of your fact pattern? The third way that the subtopic can be tested is the question of whether the injury itself is redressable. And I'll dig a little bit deeper into this question in a few minutes, but just know, is it redressable? Next up, is the issue moot? Is this whole thing moot? Is there no reason for the court to actually address this? That's the fourth way it can be tested. And the fifth way is this case ripe? Meaning, is it actually worth the court's time to render a decision on this case? Let's dig into each of these 5 questions in a little bit greater detail now. First off, what constitutes a case and controversy? The general rule to remember for this question is that the federal court cannot render an advisory opinion. This means that the court can't just render an opinion that is purely advisory. There has to be some sort of real dispute here in order for the court to have jurisdiction, the federal court to have jurisdiction over a case. They cannot simply be asked by parties to provide sort of a guiding principle that others should abide by. There has to be a real actionable dispute, a real case and controversy. The federal courts are not in the business of just giving out their opinions here. So that sort of addresses that first issue there. Let's move on now to standing, and more directly, where a party has standing. The general rule to remember for where a party has standing is a party has standing where they suffer an injury in fact or may reasonably suffer an injury in fact that is caused due to an action by the defendant. This issue of whether they are injured in fact ends up being sort of the core question of standing problems. So, for example, taxpayer standing has historically not been sufficient. I can't sue the federal government for making a decision I don't like just on the basis of being a taxpayer because that has been deemed by the Supreme Court as not a real injury in fact. Now, this may very well change in short order, but for now, that is what the Constitution provides. That is what the law is. So just know for now that injury in fact is sort of the key question of a standing question. Another example for you with regard to standing is as follows. Let's say that I want to drive a red car, and before I purchase my red car and I'm ready to drive it, I notice or I hear that there is actually a law in my jurisdiction in state X that prevents the driving of any cars that are red. This law has been in effect since the 1950s. Some congressmen put it in effect because they did not want to have anyone. Some state assemblymen put this law in effect because they could not abide the notion that some driver would have a red car. Regardless, this law has never actually been used. Nobody has actually been ticketed. Nobody's actually gone to jail for violating this law. Nonetheless, I go to the federal court and I seek to challenge this law. I would not have standing there because I have not actually sustained an injury. In fact, nobody's arrested me yet. Nobody has ticketed me. And it's not really reasonable or probable that I'm going to have an injury, in fact, because this law hasn't actually been used in the nearly 70 years or more than 70 years since it was put into effect. So just think of standing like that. Think of the idea that you actually have to have a real injury, in fact, or have a reasonable likelihood of having an injury, in fact, down the line. Next up, I know we mentioned the idea of redress ability, but this example I just just gave you speaks to this issue of redressability. When I say that the case itself must be redressable, the injury must be redressable, it means that the court's decision must eliminate the harm in some way. And in the case at bar, my red car example, the court changing that law would not really redress any injury because it wouldn't eliminate the harm because I'm not actually being harmed by the law. It's not being used. I've never been prosecuted. Nobody's ever been prosecuted under this law. Let's talk now about mootness. When is a case moot for the purposes of the MBE? The general rule to remember here is that a live controversy must exist all stages of the litigation in order for a case not to be moot. So the key example to remember here is that there was a real lawsuit, the Odegaard case, where a plaintiff sued a law school alleging that he was denied admission to that law school based on the school's affirmative action policy. But by the time that this case actually reached the Supreme Court, this plaintiff was essentially ready to graduate another law school by that time. So the court held that this case was moot. There was no need to proceed because the controversy was no longer live. There was no real controversy anymore by the time that it reached the court. So that controversy must remain alive throughout the life of the litigation. That's the general rule to remember for the idea of mootness for the MBE. When you see one of these questions, keep that in mind as you're assessing it. Finally, the idea of ripeness. The general rule to remember here is that a party cannot sue unless they've already sustained an injury or are reasonably likely to sustain that injury. Once again, this sort of speaks to what we were talking about before with standing. The case actually has to be ripe. You can't sue because you expect that there's going to be a law coming down the pike that is going to impact your life. Think of me and my red car law. That case would not be ripe, as well as I would lack standing, because there is no reasonable likelihood that I am going to be injured. There is no reasonable likelihood that I'm going to be harmed, and I have not been harmed yet by that case. So think of ripeness, think of mootness, think of standing, think of whether there is a real issue of redressability here. Whenever you see some of these judicial review questions on the MBE, on the Uniform Bar Exam, you now have these sort of basic tenets, basic rules to remember as you're assessing these MBE questions, and keep them in mind and you will score better. That does it for us. Be sure to subscribe to the channel for more of these videos. Be sure to check us out at barcastaudio.com. We have audio outlines, audio essay attack sheets, everything you need for the bar exam. We have it there, barcastaudio.com. Until then, I'll talk to you guys soon. Bye now.